open the hearing on House Bill 2480 and have the reviser come up to give a bill brief.
All right, thank you, Madam Vice Chair. Jason Thompson, Revisor's Office, House Bill 2480. You'll notice the bill brief was from January 28th, but it's still good. I don't think it's changed. The bill creates exceptions to certain mandatory reporting obligations for licensed social workers when they are working under the supervision of an attorney. It also permits attorneys to require a licensed social worker working under their supervision to maintain ethical obligations of attorney-client privilege. This might look familiar. We discussed this issue last year in the committee. I believe there are some changes. I didn't actually redraft the bill myself, but I'll kind of run through what's in the bill, and then I know you've got a lot of conferees that want to talk about the concept in the bill. The bill brief is a little different, and so is my briefing. It's because the sections are kind of grouped by topic, and they're not necessarily in the order they are in the bill. So sections 1, 3, and 5 amend the provisions there, 382223, 391402, and 391431. Those are all statutes that mandate reporting by certain persons who receive information or have reason to believe or suspect harm is occurring from abuse against children and adults. So these are those mandatory reporting statutes, all three of them. The 3822 is with regard to children. 391402 is licensed social workers with adults who is a resident of a certain healthcare facility or adult care home being abused or neglected. And then 1431 has licensed social workers with adults who need protective services or are being harmed from abuse, neglect, or financial exploitation. So there's provisions related specifically to social workers are called out in those three places, but they apply to other reporters too. In any case, what House Bill 2480 does is insert similar language in each of those statutes, specifically create an exception for licensed social workers, and it only applies when they are working under the supervision of an attorney and the reason to suspect the harm that is occurring from that particular abuse or exploitation that triggers the mandatory reporting arises solely in the course of the attorney's representation or prospective representation of a client. So those are the things that would trigger the exception to the otherwise mandatory reporting. Working under attorney and you discover the abuse or exploitation only because of that representation. The second grouping of statutes is sections 2, 4, and 6. The companion statutes to each of those three we kind of talked about in 38, 39, and 39 again. These are the ones that prohibit an employer from taking certain actions against an employee because of their mandatory reporting requirements. Currently, an employer is prohibited from terminating or otherwise impairing or sanctioning an employee because they make a report as required by law. The bill creates an exception in each of those employment statutes for attorneys to allow an attorney to require a licensed social worker with these reporting obligations to maintain the confidentiality of information in compliance with the attorney's ethical obligations under the Kansas Rules of Professional Conduct. And so these are the attorney imposes these obligations on the social worker when the social worker is working under the supervision of the attorney is providing representation, or there's a prospective client seeking their representation, and the reason to suspect or believe there's harm or abuse in these situations is what triggers the mandatory reporting arises solely in the course of that attorney's representation or prospective representation. And then the last section referenced is section 7. That's KSA 65-6315. That provides certain confidentiality requirements and exceptions for information acquired by licensed social workers in the course of their work. Currently, that statute provides that information acquired from a person by a social worker is generally confidential unless certain exceptions apply. But there is no confidentiality privilege for information that is required to be reported to a public official. HB 2480 would specify that a licensed social worker would not be required to testify on acquired information when it was acquired solely while working under the supervision of an attorney providing services to a client. And it would also provide an exception for information that's generally not considered privileged. And It would say that when acquired during that sort of work that we've been talking about with an attorney, it is privileged information, even though it might not otherwise be under the current law. All that to say, essentially, there are a lot of provisions in current law that require social workers to disclose things related to abuse, neglect, exploitation, and this would create an exception when they're working with an attorney and they acquire that information in the course of that attorney's representation of the person. I think that wraps it up, and it would take effect on July 1st if adopted. Answer questions if I can.
Great, thank you, Jason. Committee, do you have any questions for the revisor? Yes, Representative Curtis.
Thank you, Madam Chair. So this puts the responsibility then with the attorney to then advise that mandatory reporting would not be required under those circumstances?
Madam Vice Chair and Representative, yes, I think essentially because you're working, the social worker is working directly with the attorney, the obligation that's being imposed is basically the attorney's ethical obligations are being imposed on the social worker. And so they might otherwise be required to report, but in these particular cases, the attorney will tell them we can't report that. It's privileged, it's confidential. That's how I suspect it would work in the real world, and I think that's hopefully what the conferees will say as well.
Any other questions? Great, thank you, Jason. All right, for our proponent testimony, today we have up first Noel O'Neal with the Director of Social Work in Kansas Federal Public Defender. Welcome to committee, Noel.
Better? Perfect. My name is Noel O'Neal, and I'm the Director of Social Work for the Kansas Federal Public Defender's Office. I'm here to explain why House Bill 2480 matters. But first, it might be helpful for you to understand why I became a social worker. I grew up in Norwich, Kansas, population 500. In the 3rd grade, when my teacher asked me what I wanted to be when I grew up, I said, a police officer. That answer stuck with me, and by the time I graduated, I was headed to college to pursue a degree in criminal justice. It was during my internship at a probation office that something shifted. I saw people released from prison who struggled to meet the requirements of their probation. I witnessed the legal system becoming a revolving door, not because people didn't want to succeed, but because there were underlying issues that had not been addressed. That's when I knew I wanted to be a part of the solution. In 2017, I started my career at Wyandotte Mental Health Center, working alongside individuals on probation who also struggled with mental illness. I was a part of the team that established the mental health court in Wyandotte County, and I was the case manager for the first ever graduate of that program. Through that experience, I learned that many factors can contribute to someone's involvement with the criminal legal system: mental health issues, substance use, trauma. But I also began to believe in the power of second chances, and I watched as people used those second chances to rebuild and to recover. In 2022, the Kansas Federal Public Defender's Office hired me as their first social worker. One component of my job is sentencing mitigation, or more simply put, storytelling. This is the process of uncovering the circumstances that led to a person's involvement with the criminal legal system. To answer the burning question that we all have: how did we get here? Now, storytelling is not an excuse. It doesn't exempt my clients from legal consequence, and it's not a get-out-of-jail-free card. Storytelling is an explanation. Storytelling does not always impact case outcomes, but it does impact the way my clients feel about their representation. I've had many clients ask me, does talking about this stuff actually help? And my answer is yes. I have witnessed how being heard can heal broken parts of someone, and how sharing their story can impact the way that others view them. Every day, I get the opportunity to hear our clients' stories that are often painful and complex. Uncovering these stories requires a relationship that is rooted in trust. When clients fear that certain information that they disclose to me may extend beyond their legal team, it undermines that trust. It is only after trust is established that we can get closer to uncovering the answer to that burning question: How did we get here? I've come to understand that the closer we get to answering that question, the better the outcome. I've seen judges give second chances. I've seen victims forgive, but I've also seen clients go to prison, accepting their consequences with a better understanding of themselves. That understanding and that healing starts with trust. I often find myself saying, I'm just a social worker. But after taking some time to really think about it, I take great pride in the steps that I took to become a licensed social worker. It took me years of education, non-clinical and clinical internships, a master's exam, and ongoing training to earn my license. Throughout the social work field, licensure is the gold standard. It's encouraged, and in some settings, it's required. It's troublesome to hear that under current law, I'm indirectly being asked to set aside the very thing that makes me good at my job, my license. By having social workers embedded into defense teams, the risk is actually lower than it appears. In the course of this work, much of the information that might typically trigger a mandated report is historical in nature or already documented in police reports and court records. Additionally, many of our clients are in custody where they pose no risk or under supervision where they are being monitored by an officer of the court. It's important to mention that social workers will still use their clinical judgment. This would look like reporting the information to the attorney, voicing their concerns, and determining the right way forward together. In conclusion, House Bill 2480 is about more than just protecting social workers. It's about breaking the cycle. When we can build genuine trust with our clients and address the real challenges that bring people into the system, we can create the possibility for real change. Without this protection, I am being asked to choose between my license and my ability to fully help our clients. I'm asking you to pass this bill, not just for social workers, but for clients who deserve to be heard and for a system that works better when we understand the full story. Thank you for your time.
Thank you, Noel. We'll have you stick around for questions after all the proponent testimony. Up next, we have Michelle Eward, Director of Washburn Law Clinic. Welcome, Michelle. Sorry if I pronounced your last name wrong. Okay, great.
Good afternoon. My name is Michelle Eward. I am a professor of law at Washburn University and director of the Washburn Law Clinic. My testimony today is that of me as an individual faculty member and director of the law clinic. It does not reflect Washburn University's official position on this bill or the law school's official position. I am here in support of this bill because it is an outstanding bill that will allow a lot of people to better serve vulnerable Kansans. I approach this issue from two perspectives. First, I'm a licensed foster care provider in Kansas. I provide emergency and respite foster care to youth aged 10 to 18. All of the children who come through my home have experienced serious abuse and neglect. I get how important it is to protect children. I deeply, deeply am committed to that. The second perspective that I bring is that of a legal services attorney. In the Washburn Law Clinic, my students and I provide free legal services to clients who would not otherwise have access to counsel. We provide services in a whole range of civil practice areas. And prior to becoming a professor, I worked as a legal aid lawyer in the Chicago area, in rural California, and in Baltimore, Maryland. And for several of those years, the only cases I did were domestic violence, child abuse, and elder abuse cases. I helped survivors of domestic violence get restraining orders against their abusers, file for divorce from their abusers. I represented parents of child victims, obtain protective custody orders so the kids would no longer be exposed to their abusers. I care deeply about protecting kids, and that's what this bill does. It leaves in place the mandated reporting requirements for most mandated reporters. Because remember, it's not just social workers who are in kids' lives, it's their teachers, it's their doctors, it's emergency responders, it's their daycare providers. Those mandated reporting requirements continue. And further, most social workers will still have mandated reporting requirements. Kids will be protected. What this bill does is allow social workers to be embedded in law clinics and legal aid programs and public defender programs to help attorneys provide better representation. Because we know that social workers understand trauma in a way that we don't. They can connect to community resources in a way that we can't. And they can help tell clients' stories better in court so judges can reach the best and correct outcomes. This is an excellent bill. I hope that you will consider passing it. The Washburn Law Clinic would like to actually utilize social workers in our law clinic. Washburn's MSW program has students ready and standing by to do that. This bill would allow that to happen. So thank you very much, and I will stand for questions later.
Thank you, Michelle. Up next, we have Melody Brannon from the Federal Public Defender, District of Kansas. Welcome, Melody.
Thank you. I am Melody Brannon. I am the Chief Federal Public Defender for the District of Kansas. I've been a public defender for 35 years. Over that time, I've represented hundreds, if not thousands of people, and I've put together numerous defense teams that include investigators, paralegals, interns, experts. And as I put together these teams, all of the members of the team have the same ethical and constitutional duty that I do, that of confidentiality, so that we can build a relationship of trust with the client. And I was very surprised to learn in Kansas, after we hired Noel as our first social worker, that protection did not extend to social workers, and that we had to make a workaround and exceptions for this. And that's what led to us supporting this particular legislation, because all of the defense team needs to be able to have full and candid conversations with our clients. Over the last decade or so, public defense has really changed. We have become much more holistic in how we approach the defense. What I really want to do in my work in representing people is, in this holistic approach, is to find out how they got into the system and how we can help lift them out of the system. And I rely on a quote by Desmond Tutu that says, there comes a point where we need to stop just pulling people out of the river. We need to go upstream and find out why they're falling in. And it's that reason that we're using social workers, to figure out how we can best deal with our clients, not only for our clients and their families, but for our communities. Because if we can figure out a way to lift them out of the system, that helps protect our communities as well. And that's one of the reasons we want to expand our social work program. Noel's done a tremendous job getting it established, overseeing interns. But as we look towards expanding social workers into our program, I am faced with asking people that we hire, I'm either going to look for people who are unlicensed, or I'm going to ask them to surrender their license. And I don't think that's the optimal thing to do. I think licensure is very important. It encourages professionalism. It encourages continuing education, consistency, and accountability. And I don't want to be in that position. And that's why we are seeking this particular change, so that we can hire licensed social workers to come in and help us with our work and contribute to the criminal legal system and how it ought to work. Mandatory reporting makes sense in most context, and I am confident that the law did not contemplate this particular conflict that we're addressing here. Didn't really, when mandatory reporting was codified, that we didn't really think through, well, there may be this particular situation, whether it's criminal defense or family law, that a social worker could help with the resolution of a particular case. And making this exception makes a lot of sense. The amendment, I think, would also be economical. I think hiring social workers to do this work is economical for the criminal legal system. It's economical for our office, but it also encourages the hiring of licensed social workers. And I think that, too, is a good thing for our community. So I would ask the committee to endorse this change, and I will stand ready for any questions. Thank you.
Thank you, Melody. Up next, we have Ann Sagan, the Executive Director of Kansas Board of Indigent Defense Services. Welcome to committee, Ann.
Thank you. Chair Humphreys, Vice Chair Williams, members of the committee. I'm Ann Sagan. I'm the Executive Director of the Board of Indigent Defense Services, or BIDS, which is the public defender agency for the state of Kansas. Thank you for the opportunity to testify in support of HB 2480. I support this bill because I see the incredible value of having licensed social workers on attorney teams in the context of public defense. I want Kansans across the state to be able to work with an attorney who can utilize the resources, knowledge, and training that a licensed social worker brings to the table. Our agency BIDS exists because in the United States and in Kansas, everyone charged with a felony has the right to an attorney even if they can't afford a lawyer. BIDS provides for the representation for every adult in Kansas who's charged with a felony in Kansas courts through a combination of public defender offices and private counsel that are appointed to cases. We handle approximately 26,000 cases a year across the state in every judicial district and every county. Our clients are often Kansans who have faced multiple challenges, including poverty, homelessness, substance abuse issues, and mental health issues. Over the past several years, our agency has worked to improve our services and adopt best practices, including a team-based model of defense. One essential member of that team is the mitigation specialist, who are often licensed social workers. Social workers are prepared with the most skills and the most training for this work. Our mitigation specialists are specifically focused on assisting the client in connecting with resources in the community while their case is pending. They may help our clients connect with housing resources, employment resources, or drug treatment, or get free bus passes so that they can come to court. They also build a connection with the client and work to find out about their life history. They gather records to support any information that's being provided to the court, such as information about intellectual disabilities, a mental health diagnosis, or involvement with foster care or DCF as a child. They help the attorney see the big picture about the client. And that information in turn helps the prosecutor and the judge to see the full picture of the defendant before them at sentencing. They also often work with the defendant to come up with plans to help them get the long-term resources they need to stay out of trouble and build a better life going forward. And hopefully this helps the court have this case be their last case because they've improved their life and are no longer involved in the justice system. Social workers on our defense teams help us support better defense practices and long-term healthier communities. HB 2480 has been carefully crafted so that it doesn't water down any of the already existing protections for youth or other people in the community. All of those supports and reporting requirements will still remain for social workers in every other context. Instead, the bill establishes a very limited exception that only applies to social workers who are working under the supervision of an attorney. The reason this exception is so important is because attorneys, by virtue of their mandatory professional ethics, cannot share confidential information that they learn from their clients without their client's permission. This is fundamental to the attorney-client relationship and is constitutionally enshrined as part of the right of every American to effective assistance of counsel in their defense. In Kansas, this is enacted in Kansas Rule of Professional Ethics 1.6. Rule 1.6b includes several exceptions for confidentiality for attorneys, and I'll note that absolute confidentiality does not apply if an attorney ever believes that it's necessary to break confidentiality to prevent the client from committing a crime. It's also important to understand that the attorney's duty of confidentiality applies through the attorney to every staff member who's working under the attorney as well. Therefore, social workers who are working under the supervision of an attorney would violate the attorney's ethical obligations to the client if the social worker shared any information learned during the course of the case outside of the attorney team without the client's permission. So the licensed social worker's mandatory reporting requirements are in conflict with the attorney's duty of confidentiality. As you can imagine, our cases sometimes include information that just in the facts of the case alone, as provided to us in the discovery from the prosecutor, have facts that could trigger the mandatory reporting requirements of a licensed social worker. Therefore, when we work with licensed social workers, we sometimes cannot fully integrate them into our teams, and they're not able to fully assist on every case. I'm a mom of two. I value and I am thankful for the networks of mandatory reporters that provide protection across Kansas against abuse. But the provisions of this bill do not impact that. All of the contexts where licensed social workers and other mandatory reporters currently work will remain intact, including schools, doctors' offices, daycare providers, and the Department for Children and Families. Instead, this bill will allow licensed social workers to assist clients in the important context of attorney representation, which will further our agency's work to aid Kansans who often struggle to gain the community connections and services needed to successfully leave the criminal justice system behind. Thank you, and I'm available for any questions.
Thank you, Anne. Lastly, we have Jill Cohen via WebEx. Is Jill on? Okay, great. With LCSW Director of Programs, Colorado Office of Respondent Parents Council. Jill, can you hear us?
I can. Can you hear me?
Yep. Thank you
Perfect.
and welcome to committee.
Well, thank you to the chair and to members of the committee for permitting me to speak virtually. My name is Jill Cohen. I am a licensed clinical social worker in Colorado, and I'm the Director of Programs for the Office of Respondent Parents Council. That is the state agency in Colorado that provides attorneys to indigent parents who are facing child welfare court cases. I have worked on interdisciplinary legal teams for over 20 years in 2 states. Today, I'm here to share Colorado's experience updating our mandated reporting statute and to explain why HB 2480 reflects the best practices in legal advocacy. Colorado adopted similar language in our statute just last year. In 2022, our legislature convened a mandatory reporting task force to address concerns about the effectiveness of mandatory reporting laws. One key question we examined was whether social workers and others on legal teams should even be mandatory reporters. Our task force reviewed the mandatory reporting laws for all 50 states. We examined all exceptions and found that California, Louisiana, Oregon, Utah, and Washington, D.C. exempt certain professionals who work with attorneys, such as guardians ad litem and social workers, from mandatory reporting requirements. Our task force included foster parents, former foster youth, CASAs, and child welfare professionals. After our task force heard from experts in the field who expressed concern that mandatory reporting requirements for any legal team member can undermine attorney-client privilege and threaten effective representation, our task force voted to propose new language. The amendment would clarify that mandatory reporters who are employed by or contracted with attorneys, so working as agents of attorneys who provide legal services, will be exempt from reporting requirements when acting within that role. This includes social workers on our legal teams for children, youth, and parents. In front of the legislature, this language passed without opposition from the Colorado chapter of the National Association of Social Workers, the Department of Human Services, foster parent organizations, child advocacy groups, and now it is our law. Confidentiality within legal teams is essential to high-quality representation and does not decrease children's safety. I'm a parent and I'm a social worker. I am trained to recognize abuse and neglect, assess risk, refer to services, and respond to crisis. I am legally and ethically required to act when a child is in imminent danger. I do not need an additional reporting mandate to do my job responsibly. What I need is to build trust with the people we represent. Trust allows me to help them participate in their own legal representation. That trust is only possible when confidentiality is respected. House Bill 2480 recognizes how high-quality legal representation actually works in the day-to-day. It protects our professional ethics, it strengthens attorney-client relationships, and promotes better outcomes for families by giving them additional resources. It does not reduce safety. Instead, it ensures that trained professionals like lawyers can do their jobs effectively and give voice to children, youth, and families while still responding appropriately to real risk. I find that it's better to have an attorney pair with a social worker when navigating issues in child welfare, such as domestic violence, substance misuse, homelessness, mental illness, than to have a social worker be excluded because of the risk to the client's confidentiality. I respectfully recommend that you support House Bill 2480. Thank you so much for your time.
Thank you, Jill. And can you stay around for questions if the committee has any for you?
Yes, thank you.
Okay, great. Thank you. All right, that's all for in-person proponent testimony. I will note that there's 6 proponent written only testimony that you all should review. But does the committee have any questions for the proponents that are here? Representative Schreiber.
Thank you, Madam Chair. And this is more of a hypothetical, so I guess it'd be to anybody, or the attorneys on our committee might be able to answer too. But if the social worker is part of that attorney's team, but through investigations or whatever, if that social worker identifies some other that's not associated with the person that's being represented by the attorney, that restriction on the mandatory reporting would not transfer over to another instance where they might have witnessed abuse, if I'm making myself too complicated.
Oh, does anyone want to answer that? Sure. Come on up, Ann.
If the information is discovered just solely through the representation of the attorney and the client, then yes, that's covered by attorney-client confidentiality. However, I will say that an attorney, if they believe that their client is going to imminently commit an offense, they can. There are exceptions to the confidentiality requirement. Further, if it is something unrelated to the client and it's just something discovered in the case and the feeling is that information is shared, the attorney can always talk to their client about sharing information from their case. And that is always a possibility. The restriction is without permission of the client to share that information. But yes, that confidentiality, that anything learned through the case remains confidential with the attorney, that is a really fundamental tenet of the attorney-client relationship that is also related to having effective counsel.
Regardless of if it was the client that was involved with the abuse, if it was a
It's
one-off.
something learned in the case.
Okay,
Yeah.
all right. Thank you. Thank you, Madam Chair.
Representative Vaughn.
Thank you. And I think this would also potentially be a question for Ms. Sagan, kind of building on where you were going with that. I kind of remember our hearing from last year on the Senate bill, I think similarly, and that was something that came up was how this would remove the mandatory reporting requirement, but essentially lawyers and social workers have ethical obligations that if they believe imminent harm is to come to a child or a person, that they can report that and ensure that that is taken care of. So I just kind of wanted to highlight that and see if you could kind of talk about how that would play out in these situations. Because I think that'll be the concern is if a child is in imminent harm, can that still be reported and addressed, for example, through ethical obligations?
Yeah, so I think I noted in my testimony and in the written testimony, there are exceptions to the confidentiality rule under Rule of Professional Ethics 1.6b, and in that is if it is believed that the client is going to commit a crime, that could be reported. I will say, though, the federal social worker who gave testimony gave the example of many clients are also in custody while this is happening. So some of that harm is mitigated. And I will also say that about 2/3 of our cases are approximately 2/3 are non-person offenses. So these are just like theft, drug possession. Drug possession is 1/3 of all of those 26,000 cases that we represent every year. So the vast majority of our cases don't involve allegations of harm to another person.
Go ahead.
And then just a second question, because I didn't remember this from last year. Could you explain why you think it's important to include prospective clients? That was something that was new for me.
Prospective clients. Oh, is this like if you are, this probably isn't something that impacts public defenders as much as it does private counsel. When private counsel are sitting down with potential future clients to determine whether or not they are going to represent them in a case. I'm assuming this is what the question is about. They have some initial conversations that are also covered by confidentiality rules so that they can have a candid conversation with that person. In our case at the Public Defender Office, we don't choose our clients. We represent everybody who is eligible to be represented based on their financial status. So we don't have as many prospective clients as you might have in the private counsel, and maybe private counsel can provide more information, and we'd be happy to talk to some of our assigned counsel that work on our panels if the committee would like more information specifically about that aspect of the work.
Thank you.
Sure, yep.
So this comes up in my practice. Again, Michelle Eward, Washburn Law Clinic. So there are two separate ethical rules that govern confidentiality. One deals with current clients and one deals with prospective clients. So the same sort of confidentiality requirements apply to people when they are going through intake with support staff, when they're having the initial consultation with the attorney and they have not yet retained that attorney. That information is still required to be kept confidential. And it wouldn't be often that we would necessarily have social workers sitting in on those meetings, but we might. And so that's why this piece is really important. Thanks for letting me clarify.
Great. Representative Barrett.
Thank you, Madam Chair. This question will be for Jill. Hey, Jill, thank you for your testimony today. I guess, I know you already mentioned this. Can you repeat it? What states are already doing this? I just didn't catch it.
Oh, I just, let's see. I know it was Washington, DC, Oregon. I just put away my testimony. Give me a second. Let's see.
I think we got the list.
California, Louisiana, Oregon, Utah, Washington, DC, and now Colorado as of 2025.
All right, thank you. Thank you, Madam Chair.
Yep. Representative Bohigh.
Thank you very much, Madam Chair. Elizabeth, please. Or not, sorry, not Elizabeth. I'm sorry, Ann. Wrong line. I didn't mean to pull a proponent of written only. My question is this. Currently, not currently, the law is you can only act as an attorney if the harm is imminent. So if the harm has already occurred, you cannot act because it falls under the Confidentiality Act, correct? Or the confidentiality relationship, correct?
Are you talking about what our confidentiality rules cover?
I believe you stated earlier that you could intercede on behalf of something if there was imminent harm, meaning not yet occurred, correct? Imminent means it's not in the past, it's yet to occur, correct?
Yeah, I don't think I used the word imminent, but I can explain a little bit about the confidentiality rules. So everything that we learn as a result of our representation in a case has to be kept strictly confidential and cannot be shared outside of the attorney team without the permission of the client. And that's that fundamental attorney-client relationship that is rooted in confidentiality. There are some exceptions to that confidentiality requirement, and one of those exceptions is if it is believed that the client is going to commit an offense, then the attorney may go outside of that confidentiality.
To be clear, if the offense has already occurred, you are not, that's part of the confidentiality. So if there was a past abuse that you learned about that the client wasn't being charged with, that's under confidentiality.
Right.
Okay, thank you.
All right, we have Representative Carmichael.
Thank you, Madam Chair. I think my question will probably be best answered by Michelle Eward. I do have to say, though, as she's headed up there, throughout my career, I used particularly registered nurses in the preparation of cases. But when I graduated from the KU Law School in 1982, I do not remember even having a class in client counseling. And I walked out to be a lawyer with no professional training on how to interview children, be they fact witnesses or otherwise, or how to deal with people who had suffered from dramatic trauma of one kind or another. I represent people that had seen their mothers killed before their very eyes and a host of other things that we don't need to get into. But I didn't have the skills or the training to ask those questions in a professional and proper manner. It was learned by on-the-job training. So I'm glad that we have people who are professionals, who have training, interviewing children and other family members that have suffered horrendous things, because I, as a lawyer, was probably the wrong guy to try to get those stories told. With that observation, I was a little I may be in trouble with the ethics administrator. I'm retired now, so he can do it as she wishes with me. But I always construed the attorney-client privilege to be a duty to my client, not a duty to the world at large. And so in circumstances where I was representing a client, if I learned that a child was at risk, or I learned that someone was at risk for theft of, oftentimes elderly people would have their estates pillaged by people who were taking advantage of them and the like, I always was of the opinion that if it didn't implicate my client, even though I learned it during the course of the representation, that I certainly was still free to, and usually I talk to my client and say we were all in agreement. But I didn't think that the rules prohibited me from divulging information that I acquired that was not confidential from the client, but it was just in the course of the investigation. I see you nodding. I think you know what my ethical dilemma is. But because I'll tell you, I've turned some people in over the years. Not my client, but when I found out something bad was happening somewhere, of course I called police detectives. Am I in trouble?
So this actually raises a really good point that I want to clarify for the non-lawyers. So up to now, we've been talking about the duty of confidentiality that is an ethical rule that governs licensed attorneys. Representative Carmichael also raised this issue of attorney-client privilege, which is an evidentiary rule, set by statute that says that confidential communications cannot be compelled through court testimony, disclosure, through discovery, things like that. So the duty of confidentiality applies regardless of what our client goes out in the world and tells people, regardless of who else might be in that room. The evidentiary privilege of attorney-client privilege can be broken if our client reveals information if someone else is present, things like that. So that's the two different things that we're talking about here. Now, what I spend a lot of time doing with my clients is talking about, okay, I have this information. It might not make you look good, but there might be a reason it will be in your best interest to disclose that to the judge or to the opposing side. So a lot of what we do as lawyers is counseling, advising the clients about what their rights are, what their different options are, what the implications are, or likely consequences of different options, helping them sort of navigate this complicated system. And so we're advising from a whole range of perspectives, and sometimes we do advise them that we think it would be best for you, for whatever reason, to allow me to disclose information. It might benefit your case, or it might be helpful to you in some other way, or for them to disclose. And so those are conversations that we have. But when we are allowed to disclose confidential information without the client's consent, which is what we're talking about here, that's in these very, very limited circumstances. Did I answer your question sufficiently?
Your answer causes me concern.
Okay.
Thank you.
Okay.
All right, committee, any other questions for the proponents? Seeing none, I will again point out those 6 written-only testimony that you have for proponent. Now we'll move on to opponent. First up, we have Representative Lauren Bohigh. Welcome to committee, Representative.
Madam Chair, I need to raise a brief point of order regarding this.
Go ahead.
In years past, when I believe Chair Patton was the chair of the committee, the rule generally was, and Mark may have been there, and I violated it one day, that that if you testified before the committee, you couldn't question as a committee member, or if you questioned as a committee member, you couldn't testify. Now, I don't propose to cut off Ms. Bohigh's testimony. I've read it, and I think we ought to hear it. But I want at least to acknowledge that we're changing the rules of the committee from what they used to be, because at some point I might have Representative Bohigh's shoe on my foot and want to do the same thing.
Representative Barrett to address it.
Madam Chair, if I recall correctly, last year when I spoke on my AI bill, I also questioned those who were against it, and it was never brought up.
And I didn't object. But I'm saying we're violating the precedent in the committee where in the past, the rule has been one thing. And all I want to make sure is we're clear what the rule is, because next week, maybe I want to testify on a bill and ask questions at the same time.
I appreciate you raising that point of order. We will continue on to hear Representative Bohigh's testimony.
Thank you, Madam Chair, and I apologize for being out of order. Okay, thank you. Madam Chair, I come before you today to further explain my opposition to Bill 2480 regarding a carve-out of the mandated reporter statute. I would like to share with my esteemed colleagues and the proponents here some of my background and why the safety and protection of children and the most vulnerable is so important to me. I graduated from Mid-American Nazarene University in 2007, and one of my majors of study was urban studies, which has very similar coursework to undergrad social work degrees. In fact, for one of my practicums, I spent the summer of 2004 in Los Angeles at the Say Yes Center, an after-school educational program at 6th and San Pedro in Skid Row, working with children throughout the day and then taking them to the Midnight Mission parking lot for them to have cots to sleep on was, in a word, formative. After that experience, I was the first volunteer in January of 2005 at the brand new KC Urban Youth Center, an after-school program started to help at-risk youth with literacy and homework. I became an employee when they received grants to hire care facilitators and worked there for several years, eventually becoming their nutritional director. And while both experiences have had profound impact on my life, they by themselves would not have had me object so strongly to House Bill 2480. From November 2014 to July 2021, I worked at a psychiatric residential treatment facility. I was hired on as a maintenance tech, became the end user specialist for the new in-house IT team in February of 2015, and eventually became a member of the donor relations team. Throughout my time at the PRTF, I obtained the necessary certifications to work on the floor to help out when the organization was short-staffed and more workers were needed to maintain the safety ratios, especially around the holidays, so the frontline staff could spend time with family. My experience working on the floor with those children and youth are why I cannot, in good conscience, support this bill. One story of a child I worked with comes to mind. When this young girl came to the PRTF, she was immediately put on the most restrictive safety protocols because of the type of self-harm she was enacting. This child had been sexually abused and would put items in her vaginal canal and anus. In order to work through this therapeutically, her care team had a strict protocol of what she was allowed to wear, and every time she left the room, she was subjected to pocket checks and shoe checks. She was on safety showers to make sure she was not storing items that could be inserted into her vaginal canal. This by no means was the only child that had been sexually abused that displayed this behavior. She's simply the one that comes to mind because of the severity of her case and the length of her treatment plan. In a psychiatric residential treatment facility, when a client is hurting themselves or harming another, they are put in a safety hold until de-escalation is possible. The amount of safety holds this client went through at the beginning of her treatment plan and throughout her care plan were many. She was required to have 1-to-1 care ratio because of the severity of her needs. She made great strides during her time and was able to have less restrictive protocols as she improved. The fact that mandated reporters may hear about the abuse of a child and not be able to verify the well-being of that child is quite frankly beyond the pale of, and the welfare of children should never be superseded by the holistic defense of abusers. Respectfully, I will stand for questions at the appropriate time.
Thank you, Representative Bohigh. We'll ask questions at the end after all opponent testimony is gone. Up next, we'll have Sarah Hortonstein, Division of Chief Youth Services at the Office of Kansas Attorney General. Welcome to committee, and I'm sorry if I butchered your last name.
That is okay. So Vice Chairperson Williams and members of the committee, my name is Sarah Hortonstein, and I serve as the Executive Director of the Kansas Child Death Review Board, as well as the Division Chief of Youth Services at the Office of the Kansas Attorney General. I appreciate the opportunity to testify today in opposition of House Bill 2480. As you have heard, this bill creates an exception to mandatory reporting laws for licensed social workers who are working under the supervision of an attorney. In doing so, this bill allows past and potentially present abuse, neglect, and exploitation of children to go unreported in the course of legal representation. Any law that could shield abuse or neglect is not sound policy. While proponents may argue this change is meant to protect Attorney-client privilege. Kansas should not place confidentiality above mandatory obligations designed to protect the safety and well-being of vulnerable children and adults. House Bill 2480 could allow serious concerns of harm to go unreported based solely on the context in which they are disclosed. Abuse does not become less dangerous because it is revealed in a legal context. And children do not become safer when the adults around them are bound by silence. This bill also relies on discretion rather than duty. Child protection systems are built on mandatory reporting precisely because discretion is inconsistent. Even well-intentioned professionals make different judgment calls, delay action, or assume someone else will intervene. Clear, non-negotiable reporting requirements exist to remove that uncertainty when a child's safety is at risk. While confidentiality and access to legal counsel are important, Kansas law has long recognized that those interests have limits when the safety of a child or a vulnerable adult is involved. House Bill 2480 shifts that balance too far and does so without evidence that mandatory reporting in these settings is causing harm that outweighs the risk of non-reporting. In my 10 years as being the executive director of the Child Death Review Board, I've unfortunately seen the cases that slip through the cracks. When mandated reporters and others don't step up and speak out for children and action isn't taken within our protective systems, we see those fatalities and we see the loss that our families and community suffers. For those reasons, we respectfully request this committee oppose House Bill 2480. I appreciate your time and happy to stand for questions.
Thank you, Sarah. And lastly, we have Kim Borchers, private citizen. Welcome to committee, Kim.
Good afternoon. I was going to say good morning. Can I have the morning back? I'm going to lighten up this subject just a little bit because sitting in this room, my heart rate is up. There's a joke in medicine that if you want to be a doctor and you don't really want to talk to patients, they recommend that you go into radiology, anesthesiology, or pathology. And I share that with you because I've listened to the testimony today and last year, and I read it. And so often I've heard, we're not skilled as lawyers to be able to do this. That tells me there's a fault line in law school. It's not the responsibility of the legislature to help lawyers be better at their job. We don't do that for doctors. I'm here today representing victims. I sit on the board of Project to Restore. I'm married to a mandatory reporter. My daughter is a mandatory reporter as a pediatrician. And I have to tell you, when this was brought to my attention last week, I was not planning on being here. This was not on my schedule. And someone brought it to my attention, and I saw that no one was here last year and opposing it. And I'm thinking, why? I was on the phone for the past 48 hours talking to victims, law enforcement, other attorneys who are prosecutors, and they thought this was outlandish. And this is what I read to my daughter. I said, one of the proponents says, for example, while working to develop a stable home environment for a client's reintegration, I may meet with family members or community connections who are vital to the transition. I might learn information that under current law could trigger a mandatory report. In such situations, reporting may not always be in the best interest of the client or the broader pursuit of justice. Justice for who? My daughter's exact words were, this isn't holistic, this protects abusers. I'm not questioning the intentions of anybody who's here. I know anybody who goes into social work and defense law, I believe your intentions are good. But sometimes the hardest policy conversations are not about our intent, but what is the impact? And when we talk about justice, whose vulnerability are we talking about? Many defendants, yes, they are vulnerable, but children are vulnerable. Elderly adults are vulnerable. People with disabilities are vulnerable. And when I hear somebody say, well, we're going to have all these other mandatory reporters, What if they never come across that? If you are a social worker, and the key here in all of this, right, it's licensing. It's not about being a social worker. You could be a social worker and sit on a defense team, and you would not be mandated to have to do this. This is all about, I want to have the letters after my name that I'm licensed and not have to report. If you as a social worker were to see this in a hospital, a home visit, in a school, without hesitation, you would be required in any other environment to report. So why would our expectations change just because the professional is part of a defense team? Abuse does not change based on context. I fully support the right to counsel. That protection matters. But this is about the philosophy of defense. This is the philosophy of defense policy. That's what they are asking you to do. Approve their philosophy of defense policy. And I'm going to leave with this story. I worked for the governor for 7 years. I think I lived probably in a pretty sheltered life until you work for a governor and you're around DCF. You read lots of reports of abuse. I know the stories of the women who are at the Project to Restore home. But I'll never forget a young girl, and I will not mention her name, when I was the chairman of the Jobs for American Graduates. She was at T-High. I walked into the room there at the library, just visiting, hearing their story. You as a legislature support Jobs for American Graduates. It's a great program. This young African-American girl, beautiful smile on her face. She proceeds to tell her story. Her mom was a drug addict. Fits under probably some of these public defenders who they'd be representing. Her mother was selling her at the age of 4 and her sister at 6 for her drug addiction. Now we know that the role of the defense attorney, right, is you guys do a lot of plea bargaining and, hey, can we get this back down, and maybe mom won't need to stay in jail so long. But if we use the example that you have here, if this mom came back after we lower her charge, she could go back and start selling her girls again. She disclosed that in this interview. I think the question that was posed is, past crimes won't be referenced. I'm standing here today as a citizen and as someone representing the hundreds of victims, and I am begging you, do not vote for this. This is not in the best interest of anybody in the state of Kansas, victims, children, or communities. So thank you very much.
Thank you, Kim. All right, that does end our in-person opponent testimony. We do have, it looks like 4 written-only opponent testimonies, so please review that. But now, committee, I will open it up to any questions to our opponents. Representative Carmichael.
Thank you, Madam Chair. My brief question is for Ms. Borchers.
Representative Carmichael, it's always good to see you.
I was just getting ready to say, a pleasure to see you again, Ms. Borchers. I just want to make sure, though, for clarification purposes, folks understand that when you reference the time you worked for the governor, that was Governor Sam Brownback, correct?
Yes, that was Governor Sam Brownback.
Thank you. I just wanted to make that clear, that you worked for the Governor Brownback as opposed to the current occupant at Cedar Crest. Thank you.
Any other questions? All right, thank you.
Thank you.
There is no neutral testimony, so I will close the hearing on 2480. That is all we have for today. I do have some housekeeping on different notes. We will be hearing House Bill 2437 tomorrow, and we will be working 2352, which is the clergy bill, 2479, which is ankle monitors, if you remember that one. And then we will circle back to the bill that we tabled, was that yesterday, 2419, and also we will be working 2460, which those were the Cora bills. And then lastly, we will be working 2536, which is the Alzheimer's training bill. I do want to note that the committee assistant did send out 3 different documents concerning that Alzheimer's bill. So those should be in your emails And those will also be in the S drive as well. And then we do have an approval of minutes. Those minutes from January 13, 14, and 15 have been sent into your email for you to review, and we will vote to approve those minutes tomorrow. So if you don't see those minutes in your email, please let Lene know, and she will resend them for you. Outside of that, that's all I